discussed having an amendment to remove so that there's no question that the child conceived in rape will not be considered not a person, because I just, for the record, want everybody to know I'm a person, and I feel pain and everything else just like anybody else. And so we are not cannon fodder, we are not a bargaining chip, and we are persons. And so the 14th Amendment says that no state shall deny a person their right to life without due process, and that no state shall deny a person equal protection of the laws. And so this amendment with an additional amendment made to it will ensure that no one is denied equal protection, including rape victims and their offspring. The court said in Roe versus Wade that if unborn children are in fact persons, then they'll be entitled to their 14th Amendment rights. And then they did a survey of American law, and really the law is schizophrenic. You have the right of an unborn child to have the right to inherit can be secured. Every state authorizes a judge to appoint a guardian ad litem, and we were asked about due process, and this is how the due process works. They're appointed a guardian ad litem to represent their right to inherit. And right from the moment of conception, if someone dies, there's an analysis. If a woman later says she's pregnant, they have to determine was the child conceived before or after that person died. Because if the child was conceived before the person died, they have a right to inherit that is fully capable of being legally protected. And the court then must appoint a guardian ad litem to represent their best interests to protect that right to inherit, yet they don't have a right to life. Every woman of childbearing age knows that she has to wear a lead apron if she is having an x-ray, because that right of that child has to be protected. A right to be protected from harm, right from the moment of conception. We've banned certain things like thalidomide to make sure that children are protected from harm in the womb, right from conception, yet they don't have a right to life. And so really the law is schizophrenic. And so now we're going to make sure that they are protected in the whole sense, because that's what the court in Roe v. Wade said. They concluded that the unborn child has not been recognized as a person in the whole sense. Those are exact words of the court. And so I believe that's a directive to states that if you want them to be afforded their 14th Amendment rights, then you need to recognize them as persons in the whole sense. How do you do that? You do that with a personhood amendment. And that's what we're looking at here today. And I also represented the mother in Michigan's frozen embryo case, so I co-founded Embryo Defense. Right now, my co-founder, an attorney, Alessia McQueen from Missouri, is fighting for her embryos in the Court of Appeals here. And let me be clear, these children, the doctors testified at deposition that they are living human beings. That is science. That's not an opinion, that is science. They are living human beings. And let me tell you, if these clinics are not transferring living human beings into a woman's body, or if they're not freezing and thawing living human beings, then they're not going to make any money. And they're going to be sued. Their whole practice is dependent on the fact that they have living human beings here. And the doctors further testified that they have a gender, and ascertainably so. We know in the high-profile case, Nick Lowe versus Sophia Vergara, that they have 2 frozen daughters. They're females. They're not an it. They're he or she, and they have a gender. And they are worthy of protection. And so I am encouraging you to support HJR 98 with the amendment to make sure that the state will not be allowed to discriminate against rape victims and their children. And we need to have personhood secured and stop our law from being schizophrenic. And this is about the humanity of the child, that I deserve to be protected. Every child deserves that same protection. And I just want to thank, again, Representative Moon, because you really are, you're my hero. Thank you. I'm very
no display of approval or disgruntledness with the testimony. Thank you. Ms. Kiesling, thank you very much. You are alluding to an amendment. Is there an amendment going to be offered, and where would that be offered, ma'am?
May I answer that, Madam Chairman?
Yes.
We do have an amendment that we're working on. It will, on page 2, line 12, after the word abortion, there will be a period, and line 13 and 14 will be removed.
All right. Thank you.
And we plan to offer that as a committee amendment, committee substitute bill.
Okay, thank you. Let's see if there's any questions from the committee. Are there questions from the committee? Representative Conway. You may.
Thank you. I understand you're a lawyer?
Yes.
Okay, well, good. Maybe you can answer a question I've had for quite some time. My phone, everybody. Okay. One question I have with the Supreme Court's decision on Roe versus Wade, and with the new scientific evidence that we've had that proves what they said it could ever happen, that the voters change, turn it. Why do you think, you have an opinion, why that hasn't been done?
Honestly, I'm from Michigan, let me just say, where we've never had a rape exception in a single law, because Right to Life in Michigan is a no exceptions, no compromise organization. So you're not going to get their back endorsement if you make a rape exception. And I feel like nationally, there's been just a lot of celebrating mediocrity and sort of satiating the masses that, well, we'll just give you this little bit, and there's been a reluctancy to really do anything bigger. We see in social movements that groups that are relentless, that keep bringing things back, no matter what the Supreme Court is saying, they eventually have been successful. We've seen that in the last couple of years, that on human rights issues, that they achieve success because they won't quit. And you've had this philosophy with certain pro-life leaders, especially on a national level, that, oh, we can't do anything, we can't try anything because, oh, look at the Supreme Court. Well, I think that that's been a failed strategy, really, for the last 4 decades that haven't gotten us any further. They'll point to Gonzalez v. Carhart. That's the U.S. Supreme Court decision back in 2006 that upheld the partial birth abortion ban from Congress. And in that decision, the court was talking, it's the most gruesome decision you'll ever read in the history of the court. They go into graphic details of all the different ways you can kill a baby who's in the process of being born. Partial birth abortion is just one of many. I mean, it's really sickening. And then the court says that they feel comfortable upholding this particular method because there are clear anatomical landmarks, meaning whether the navel is showing, depending on which way the baby's born, whether the navel is showing. First of all, any medical professionals are like, what navel? There's no navel. There's umbilicus, okay? Geniuses. And then secondly, they talk about, or whether the nape of the neck is showing, depending, because you know how offensive navels are, right? I mean, pro-life people apparently can't sleep at night if the navel's showing. I mean, this is the mediocrity we've settled for. A baby who's in the process of being born. And then the court said that, and besides, for any physicians who feel like it would still be beneficial to suck the baby's brains out, you could still do it as long as you provide a lethal injection first. Okay, have we done anything? And then you had 2 sign a concurring opinion. You had Justice Thomas and Scalia, God rest his soul. You had them sign the concurring opinion that said that we agree with the majority of the court, but we just want to make it clear that we don't agree with them upholding Roe v. Wade and his progeny. So we don't agree that there's a right to an abortion in the Constitution. So with only 2 of them signing it, by implication, that means that Alito and Roberts don't agree with that. And so you start adding that up, we were at a 7-2 vote. Today we're at a 7-1 vote right now. And so if you're going to hold your breath and keep counting on, a Republican president to get us to, a 5-4 vote, that's going to be another 4 decades. or more, and they keep screwing this up. They're not even getting it right. And so if you're just going to wait on that strategy, you're going to be waiting maybe 100 years before there's a change. We need to keep this going. We need to keep the momentum going. We need people to understand that to be pro-life means that this is a civil rights issue. This means that these children should be protected. It's not that we don't like abortion, we want to limit abortion. Yeah. It's that they're worthy of protection just like I was. I feel like my life was spared from a burning building. And the most egotistical thing would be say, oh, well, at least my life was spared. Like, I deserved it, but I don't. There's nothing more special about me than anybody else. And as I have the opportunity to go back and save others, I'm going to do it because their life matters as much as mine. And I feel like my life was spared for a purpose. This is a gift that I've been given. I'm thankful for. And so I'm going to do everything I can to protect others. And we know just by having this issue on the ballot, we've seen the documented in states that this issue comes out of the closet and it is thrust into the public forum for debate where it's going to be discussed because people will have to vote on it. And just by having the issue of abortion discussed changes people's hearts on this issue. There were documented cases of babies that were saved during these campaigns just because the issue is going to get discussed. And there's going to be certain non-issues that the abortion advocates are going to want to try to discuss. They're going to try to make certain things non-issues. And we got to prevent them from doing that because one thing they don't want to do is they don't want to talk about abortion because abortion is ugly. Abortion kills. That's what it is. It's killing. We're not talking about prematurely terminating pregnancies. I prematurely terminated 3 of my pregnancies, which may surprise you to hear that knowing my testimony. My daughters are doing quite well now because we induced labor. Okay, what are you talking about? We're talking about not prematurely terminating a pregnancy. They're talking about killing a preborn child intentionally. And that's horrific and it's wrong. And they don't want to talk about this, but it's going to get talked about because you're going to get it on the ballot. So that it can be discussed and lives will be saved just through that process alone. And we need to keep reminding people what it means to be pro-life. It's not going to be a name only.
All right, thank you. That was, I've always wondered about that because, I think it's important that we realize how important life is. And the importance of, I've worked with a lot of people that, different ones that had abortion, and it affects more than what people really realize. And I think it's something that, I support this bill, and I just hope that we can get some of those truth on that.
Can I answer Representative Meredith's question? She asked a question about earlier to Representative Moon, and I would like to answer that question. She was asking about who would be prosecuted, who would be the defendant. And first of all, this is not criminal law. So the language authorizes the state to act with respect to the issue of abortion. This is constitutional framework. Just like, the First Amendment right to free speech, that's when you start asking, well, who's a plaintiff, who's a defendant? Well, it all depends. This is only constitutional framework. Later, the state could enact specific laws, but this is not a criminal law. Sometimes you have, when it comes to due process, you have cases where it's a probate case, and you have in re in the matter of, and it could be unborn child so-and-so. Just like in a probate case, the right to due process, there is no plaintiff or defendant. It's in re, in the matter of so-and-so. And so it's not always a matter of a criminal case or plaintiff and defendant. But this is not a statute. This is constitutional framework. Does that answer your question?
Representative Brad.
To inquire. Representative Moon alluded to, the Dred Scott decision, and that's one thing that I think weighs really heavily on what we're discussing today about, moving forward with an amendment. I mean, because that's exactly what we had to do as a nation to end slavery. The day there would have been no ability for the legislature to really move forward with ending slavery. It wouldn't have happened. So it had to be an amendment, a constitutional amendment, and not to mention a civil war that killed hundreds of thousands of people. But I mean, this is a big issue because we're talking about denying human rights, or not just, constitutional rights, but human rights to human beings. And I think it's pretty sad as a nation that we haven't learned from history. We're actually, repeating that. And it's sickening to me that this type of thing occurs. It's funny, I have 5 kids as well, and to hear, people that have numerous children, it warms my heart to hear big families, because that's pretty few and far between. But I think weighing in and allowing the population to weigh in on a subject like this, that's what makes an HJR, a great avenue for this. Because this isn't just the legislature, weighing in and dictating what's going to happen and dictating policy. This is the state of Missouri going to the ballot and saying, we say this is life, or we don't. There's no guarantee that this will pass on the ballot, but this is allowing the people of Missouri and the people with our constitutional republic to weigh in on a very controversial subject. And I think it's way past due. I've sat on this committee for, this is my 6th year sitting on this committee, and we've never had anything like an HJR, come through here about finally, hitting the nail on the head instead of skirting the issue. So thank you for your testimony, and thank you, Representative, for bringing this.
Thank you.
Representative.
To inquire, Madam Chair. Good afternoon. You mentioned a lot about your views in terms of life. Where do you stand on gun rights?
On gun rights. I support a right, let me just say, a right of self-defense. Okay, even as against an innocent aggressor. In the law, we have something called the innocent aggressor rule. You learn about it in law school. I've written extensively about this issue. So we have a right of self-defense.
Well, you mentioned a lot about, your views of human life. You mentioned a lot about the Supreme Court, even having a Republican president potentially to, really affect the Supreme Court future decisions. But, we talk a lot about life in this Capitol. However, we're losing lives every single day due to gun violence. There seems to be a complete divide in terms of not just our state and to our country, in terms of
Representative Newman. Do you have a,
Yes, I do have a question.
opening.
I do have a question.
I think that you're getting to a point.
Yes, Madam Chair.
Thank you.
Because we talk a lot about life, but yet this argument, we'll go to the next hearing, we'll have a bill about allowing people to not protect themselves, and actually in terms of children, you talk a lot about children here in this bill, and yet this body puts more rights in terms of, or more emphasis in terms of gun rights, in terms of protecting those children's lives. So where do you stand on allowing us to protect children who are in danger every single day of being shot?
Oh, I would love to see guns in the schools for children to be able to be protected. There's been lots of crimes that have been stopped because someone had a gun and they stopped the criminal. We just had
You are in
situations like
favor
that
of children having weapons in
No,
elementary
not
schools?
the children, but to have someone there to protect them.
Representative Newman?
Yes, well, excuse me, Madam Chair, we're talking about life. That's what we're
But you
hearing
are-
about the protection of
Thank
life
you.
in this
That's the
resolution.
conclusion. Thank you. That is your conclusion.
Madam Chair, I
Unless
still
you
have
can
the floor,
talk
and I would
about-
like to ask the
I will take
sponsor.
the floor from you, Representative.
This
Now,
is
are you
duly
going to
noted. This
stay
is duly noted, Madam
On
Chair.
topic. You were talking about guns in schools and whether or not the witness supports guns in schools. Now, if you'd like to talk about life, that would be all right. Can you frame your question in that way?
Yes, Madam Chair. The witness, and I don't mean any respect or disrespect, but you talk a lot about a life, and yet the other issue that we deal with completely here in the legislature is that we turn our backs when we've got innocent children that are being shot by no fault of their own, again, through quote, accidents in the home, and yet don't we deserve in this legislature, or even in our state constitution, even in your state constitution, to protect life in those situations also, or is this just unborn?
I believe every life should be protected. The witness does not need to answer the questions. Thank you very much for your testimony. And now we'd like to, because in the interest of time, I would like to move on to a witness who is in opposition of the legislation. Thank you very much. Good afternoon.
Hi.
How are you?
Good. So thanks for having me here to speak in opposition of I'm Ed Weisbart. I am a family physician in Olivet, Missouri. I'm on the academic faculty at Washington University in St. Louis, although I speak for myself and not for any institution. I'd like to tell you about one of my patients briefly, a woman I'll call Sophie. She was raising 2 children with her husband. 2 weeks after we helped deliver her second child, she developed a cough, became difficult breathing, became very fatigued, and we diagnosed her with what's called a peripartum cardiomyopathy, which actually has pretty high mortality. She survived with extensive treatment, and over the next few months, she came back to nearly normal. We advised her to go on contraception because currents of a pregnancy would be disastrous for her. 2 years later, despite that advice, she came back pregnant again, and she knew there was a very real chance of dying with this pregnancy. So she and her husband carefully thought about it, decided to protect their 2 living children by having a first trimester abortion before she became too ill. This was not an easy choice for her or her husband. Neither of them personally supports the idea of abortions, but they love their children, and they made what is literally a Sophie's choice. I'm here because this bill would interfere with her legal right to determine what's best for her family, and it would frankly do nothing to protect the health of women, as Representative Moon said. I don't say this lightly or casually. I understand that everybody in this room has thought and probably prayed extensively about the question of when life begins, and I frankly applaud you all for that honest passion. I know there's nothing I can say today that will alter your opinion about when life begins, but I'm hopeful I can convince you that unlike what we've heard recently, this is just an opinion and not a scientific fact. And let me expose it like that if I can. To prepare for this session, I actually went back and reviewed my textbooks on embryology, specifically Langdon's classic textbook. I reviewed the process of molecular signaling, gametogenesis, fertilization, cleavage, blastocyst formation, vasculation, the establishment of body axes, and other things, and nowhere did I find a scientific discussion about which moment a blastocyst or a gastrula or an embryo becomes a human life. Nowhere did I find a statement that the first unique, that we can define it based on a unique set of chromosomes. If we did, well, how many of the chromosomes? We all have many. We don't all have all of them. And many of the chromosomes we have, the genes we have, we share in common with other animals. So how many of these, if we define it as a unique set of chromosomes, just how many does it take to meet this threshold? My point is that there is really no medical or scientific basis to draw a red line here. And doing so creates untold harm, as in my case I described to you. This law, as written, would impose the legislature's personal opinions onto the overwhelming majority of women. It's not denying some of them even access to basic women's health care. I know I haven't changed your opinions about when life begins, and that wasn't my intent. But I hope you recognize that it is just that, a personal opinion, and not a medical fact. I hope you're starting to see how inappropriate it is to enshrine these opinions, no matter how heartfelt and sincere, and I grant you that they are, into legislation. If you want to do something to save lives, focus on something that we know would actually save lives of people who are walking around. Expand Medicaid. That's not a Sophie's choice.
Thank you very much. I feel like you've had to rush through that just a little bit.
Well, this big crowd, I didn't want to take time.
That's very comfy. Now tell us again, you're in family practice?
I'm a family medicine physician, correct.
And you practice in what area of the state?
I practiced in Chicago for 20 years, and now I volunteer at Washington University and in St. Louis on at least a weekly basis in other 3 clinics all over the country. I'm retired from my full-time profession, but I volunteer at safety net clinics, helping people who don't have access to healthcare otherwise. I do it for free as a volunteer.
Great, good, thank you, appreciate that. Now, would you walk us back through the choice that needed to be made there for the family that you shared?
Sure. This couple was not a couple that was comfortable with the idea of abortions. They were religious, as I recall. And she in her second pregnancy became really sick in the immediate postpartum period, about 2 weeks later, and had heart failure. That has a high rate of people dying when they have this problem, and it tends to come back in subsequent pregnancies worse when it comes back. So they were in the situation, I don't know why she didn't prevent pregnancy, but she didn't. And she was in the situation, no one is 100% on that. And when she came back early in the pregnancy, she did recognize it early, and she knew that she was facing a problem, that her husband would have to be raising her 2 children alone if she died, and she didn't want to make that happen. So she decided that it was early in the pregnancy. She did not. So she decided to have the abortion, and it saved her life, I'm quite sure.
The stress of the pregnancy, you felt like would have
It's not
led
just,
to complications in delivery? Or?
Not exactly. It's not really a stress-related condition. I mean, stress makes it worse, of course, but it's not. No, it's actually.
Why do you say that it saved her life?
Well, this condition is an autoimmune antibody-mediated condition. No one's really quite sure what starts it, but it is autoimmune mediated. So, even in the most calm and quiet environment, those things still happen. And there was a, very strong probability, I don't know the exact number, but more than half chance that she would develop the exact same problem, only worse. And across the board, this particular condition has a more than 10% risk of death to the mother. In some cases, it's worse, and probably on recurrent episodes, I wouldn't be surprised if it were worse. At any rate, she had a decision to make that she did not make casually. It wasn't the decision she was at all comfortable with, but she decided, after careful consideration with her husband, they were both in the room with me when they were talking about it, that this was the right decision for their family. And I'm here to say that they should be the ones that get to make that decision.
How many pregnancy, how much maternity care, how many patients in that mode of care do you feel like you've given over the years?
You're asking how many pregnancies I've delivered? Probably about 1,000. Okay. It was part of my family medicine practice. It wasn't about 1,000, I guess. This is an uncommon condition. This isn't less than 1,000 occurrences, so it's uncommon. But there's all kinds of similar situations.
Yeah. Is this the only kind of situation you've seen like this in your practice, or have you seen others where there was a decision that needed to be made in the pregnancy?
Yeah, I've got another one for you if you want to hear another one. A woman who had congenital heart disease called Eisenmenger syndrome, and it's a dreadful condition, which is at the time wasn't very easily treated. Now we can actually do more corrective anatomical surgeries. At the time, that really wasn't an option. So she had really a disastrous heart condition herself, and she got pregnant. She got pregnant, and she didn't have the abortion. And at about 26, 28 weeks, I forget exactly when, she died, and the fetus died. That was again her choice, and I would fight to the quick for her to be able to make that choice on her own in either of these scenarios. But that's the point, is that it's got to be the woman, and maybe her family talking about it, but it's got to be ultimately the woman whose body it is that we're talking about making that decision.
Other questions from the committee? Senator Pacer? You may.
Thank you. Since you brought up textbooks and your research that you did for today's hearing, and you just referred to a woman who was 26 weeks pregnant with a fetus, what I would like to know is, do your textbooks say when chromosomes or the other terms that you use, when do they become live?
The answer to that is no. Textbooks don't say when life begins because, I mean, think about it, Representative, there is no scientific way to answer that question.
So when I'm sure you saw the video, and I'm sure that infant that we saw in that video was not even at 26 weeks. You still refer to that little person that yawned and sucked its fingers as a fetus?
that would be the technical definition of the term, using words as defined in the English language. Yeah, that would
It's
be
defined
fetus.
in medical language, not in,
You can make up whatever words you want to represent it. That's a fetus.
I've always wondered when people think that there's a fetus, on what day does a fetus become life?
The day it's born.
The day it's born?
Yep.
So if someone were to terminate a pregnancy 10 minutes before birth, it's an abortion. 10 minutes after, it's murder?
So you're asking a hypothetical situation which is nowhere near the current state of law in the country, and it wouldn't be law that I would support.
But when a baby's born, that's when it's life. I guess that would be my assumption. If you don't think a baby's a baby until it's born, then I just can't believe the doctor would even say that.
So what's so special about the moment of fertilization? You can't fertilize an egg if you don't have the proper to fertilize the egg. So why don't we declare that sperm cells are human lives, because they have the potential, and that all ova are potential human lives. They have that potential. And if you, I mean, there's no, the point is that's absurd. That's all absurd. And you can make an absurd argument on the far end at 39.9 weeks like you did, or you can make an absurd argument on the other end like I did. My point is, this is a subtle, nuanced, difficult question with which we all wrestle with, and many of us pray on this. And to impose one person's decision on that, to impose your decision on me or mine on you, those are not right. We shouldn't do that. It's the woman who can make this decision.
Have you performed abortions during your medical care?
No, it's beyond the scope of my practice. I've referred women to abortions, but actually doing it is beyond the scope of my practice.
Thank you. Representative Allen.
Of course. And I'm going to give up my earlier question. Representative Haefner just asked a question, and you just responded that many of us, in your words, pray on this.
But that's true. I don't know that well, that that's true, judging by folks here.
Spell that word, pray. I'm not sure which way.
I'm trying not to be sarcastic to you. I appreciate the same decency returning. As easy as it is for both of us to do that, I am not doing that.
I asked him to spell the word. No, just with Representative
She is
Haefner.
referring to your response as Representative Haefner.
Yeah, she's asking whether I'm saying that people are preying on, in terms of attacking and looking at adversarial relationships. And you know that that's not what I meant. You know that I meant a religious, thoughtful, introspective study of this. And I'm insulted by your having done that. And I have not insulted you, temptingly, as it is at times.
I apologize for that. I would just like, Madam Chairman, make a comment. Thank you. I am a physical therapist. I've worked on many, what you would call maybe fetuses, but you did say when life begins, or you say when a fetus is born. It's hard for me to call a baby in utero that you have pictures of and you see stuff from their thumbs. I can't call those fetuses.
Then you're not using the language. That is the definition of the term.
I understand what the definition of the term. Could you tell me when pain begins?
I don't know that we have a definitive answer to that question. We know when startle responses and things happen.
Do we know when babies suck their?
And I'm sorry, but I also don't know how that leads into the definition of life beginning as a one-celled fertilized ovum. I'm pretty confident that a one-celled there's no evidence that a one-celled fertilized ovum in any way demonstrates that it's felt pain. And this bill takes it back to that point.
Okay.
And leaves us in the dark times.
And my question is, and I guess my comment is more based on the fact that when many of us have seen pictures, ultrasound pictures of our would-be, I'll use your words then, of our would-be grandchildren, is that what you believe should be in there? Or would those be our grandchildren?
I think that's up to you to personally decide. I'd also like to point out, the bill we're talking about goes back to conception, or I don't know how far back, certainly fertilization. That was nowhere near relevant to the discussion. That's, I'm going to guess, 20-week pregnant fetus, which is already beyond the pale of most legal procedures that we're talking about. To show a video of a 20 or so, I don't know, maybe they can tell me how many weeks it was, to show a video of a 20 or so week piece is just inflaming the discussion without going to the evidence and the science of this, which they claim to wrap this up in. They claim to be wrapping this in science. That video was not scientifically related to the topic at hand.
And I did not see the video, so I can't respond to your video. I just think, okay, one more question then. If you have a pregnancy, a pregnant woman, and you have this, you call it fetus, I'll call it a baby, at 20, say 24, I've worked with babies 24 weeks gestation. Say it's 28 weeks. I've always felt, and I am not a physician, so I've not done surgery, but things I've read is a C-section, you slice open the skin and the uterus, and you can lift a baby out. You lift the fetus out and it becomes a baby, trying to be respectful of your children. Is that something that would endanger a mother's life?
A cesarean section? You're asking if a C-section has any risk to the mother? Of course it does. It's small, but it's real.
Do you have a percentage?
No. It's in the single digits. If it's that high, I think it's probably a fraction. I'd be making up the answer, so no, I don't know that percent. But it is very small. It's one of the safer procedures.
Okay. Well, and that's my point. Often it's like you don't have to suck the baby out, or you don't have to kill it, or you don't have to do anything. And if a parent, if a woman and her husband or partner really struggled with an issue, I would think there is a very small percentage of that C-section being life-threatening to the mother.
Are you saying the first case that I presented to you, that one of their choices was to carry it as far as she could physically, and when she became too ill to continue the pregnancy, they have the C-section?
No, I'd say even to care, not to carry it until she got too ill, but to know, when a baby is viable, based on where she is medically.
I'm really sorry, Ursula, I don't quite understand what you're asking me.
I'm saying keep the baby as long as you can, as long as you don't jeopardize the mother.
Oh, you're saying you know better what that family should have decided. So
I'm asking if that would be a decision that a family could make.
I mean, there are circumstances when that is the case. I'm not sure I understand your question.
Thought it was clear. Thank you.
Representative.
Okay, we need to talk a little bit about terminology.
Okay.
We've had a hearing here about embryos, frozen embryos, and the egg has been fertilized by the sperm, and we call it an embryo, right? And then it goes to like 16 cells, I think it is, 16 or 32 maybe, when they freeze those embryos for implantation somewhere down the line for this couple. So those are called what? Those are called bioplasts or embryos, or what are they?
I'm not a master of reproductive fertility. I believe that's an embryo at that point. I'm not a master of the language of that.
Okay, and then there's this period of time between the time the egg is fertilized and it implants in the uterus. Do we have a different name for that at that time, those cells at that time? Or they're still an embryo?
Again, I confess that I have not completely mastered which stages the blastula and the gastrula, and there are, depending on how finely you want to characterize that, there's a lot of granularity to that, and I'm sorry.
All the way along the spectrum.
Yeah.
So as long as let's see, I got fetus, called fetus, is growing inside the mother. It's a fetus. When it's born, it becomes a baby. Is that the medical definition then?
I think
It's a fetus
that's
until
the
birth,
common,
and then at birth it becomes a baby.
I believe that's the common understanding of those words.
And
Yeah.
then when it walks, it starts going around, and it's sometimes a red rat, and then they learn how to walk, and we call them toddlers, and then they become, I call them teenagers. So it's just a matter of basically what term we want to use at what stage of life. And these cells must be alive because they can reproduce. Is that true? I mean, going backwards, back to the beginning again.
Well,
A lot of the
how
cells
do you-
themselves are alive.
So how do you define life versus how do you define human life versus how do you define potential life? These are all interesting and important questions and come down to philosophy and opinion and conjecture rather than a scientific really answer.
Right, well, different religions have different times. As some believe that life begins when the egg is fertilized, some believe that when the egg implants, some believe that at a certain age that they can, abortions can still be legally done according to the Supreme Court. Some believe that with the first breath. So I think it's a religious question. It's, I think we're using terms that we have a really hard time defining. We can name all the different pieces along the way, but we can't seem to figure out when life begins. So it could be a fetus. A fetus is just a baby that's not born yet.
Okay.
Okay. Just wanted to, because I think of it as a spectrum.
Yeah, it's a spectrum. That's true.
Okay, thank you. Representative Brad.
To inquire. Well, we're having a lot of discussion on when life begins. If someone were to fall over here and die, what would you check to make sure that they were dead?
I would go through the basics of cardiopulmonary resuscitation, airway, breathing, circulation.
So a heartbeat, okay, brain activity, things of that nature would determine that, correct? I mean, that someone is alive, I mean, you're determining, well, I know the brain activity would stop later, but you'd be checking for a pulse.
On your hypothetical here, the two things that you'd be able to check for would be pulse and respirations.
Okay. Well, I mean, so that's there before birth occurs in a fetus, I guess.
So are you saying we should pick out particular biologic parameters?
I mean, you made the statement that life begins at birth.
I didn't say that. I did not say life begins at birth. I said no. No. I never said life begins at birth. I said that
The baby's
a baby
life begins at
I,
birth.
all I said were the terms are a fetus until birth, a baby upon birth. That was what I said. And I'm not disputing that someone else wants to use the word for other words to define the term of that. I'm just sharing the language. I never said life begins on Tuesday. I know I didn't. If I did, I misspoke.
Okay, because I'm pretty sure that's why I was kind of confused. If you're going to determine death by heartbeat and that there's no brain activity and all these parameters to determine death, the things that would determine life are way into the early stages of even a pregnancy. So I guess if you determine death by that, you apply those same principles to pregnancy. That would basically be at the very beginning of pregnancy.
So the point I was trying to make is that this is a very complex, nuanced, graded spectrum of stages. And
Well, I think a lot of
artificially
times that we try to get so nitty gritty into the weeds scientifically, we don't really look at the true just nuts and bolts of biology. To say that, here in America, if you say crush an eagle egg, you could go to jail because it's an eagle, even though it hasn't come out of its shell. I mean, it's still determined that is an eagle behind that egg, but yet in utero of a life, it's not considered that.
So if we were talking about abortions or some procedure at 36 weeks of pregnancy or 39 weeks of pregnancy, and I'm not sure how far earlier is appropriate to go, but if we were talking about that we would be in complete agreement that a procedure at 39 weeks of pregnancy, that's not right. But what I'm saying is that there is a point beyond which it's a matter of conjecture and opinion to draw. So currently we have a point, this resolution would draw it back to, it says any stage of biological development, I think is what it says. And I would argue that the way that's written suggests gametogenesis, suggests sperm and ova, because that's a stage of biological development. So my point is not that that's appropriate. My point is there's a spectrum here, and you can't arbitrarily draw a legislative line.
I know we've talked that we could sit and argue it, all day long on how we feel. But, I'll go back to the Dred Scott case of where the people who owned slaves didn't believe the slave was life. They believed that they were property. Just because you believed that they were property doesn't mean that they were not human beings and they did not have constitutional rights. You see, I guess that's where it leaves me with people that are pro-choice, that this is not life, so I have the ability to dictate to this other life my will on. See, and that's exactly what's left out of this whole equation, this argument of the other individual that's life is being terminated in this. You see, the mother's life is still going on, their heart rate is still the same as it was before the pregnancy. You see, a heartbeat is ended, and it's not the mother's. And that's the parallel that's never discussed or seems to be beating around the bush in this argument.
So it's interesting to bring up Dred Scott. That's a really interesting thing to bring up, because number one, slaves were defined as slaves because of legislators who wrote the law that common sense would have said is ridiculous. That's what started it, right? The Constitution said.
Supreme Court that ruled that there are individuals that are not life. And here we are trying to fix that wrong. And you were saying we are wrong.
It's a weak metaphor, sir. Plus, if you recall,
it's using your exact argument against exactly with the Roe v. Wade case. Thank you.
Oh, sorry, yes. Did you do this a witness form?
I did.
Thank you very much. All right. Representative Neely, we have for 32 seconds left in your hour. Why don't I extend this for another half hour? And you need to help to keep your witnesses at 2 minutes, please. Okay, we're ready for the next, and we'll go back and forth between pro and con, just to distribute that time as fairly as possible. Thank you.
Hello, thank you very much. My name is Diane and I'm a registered nurse and have been a registered nurse for 32 years. I will try to expedite in what I have here. Science teaches without reservation that life begins at conception. It is a scientific fact that an organism exists after conception that did not exist before conception. This new organism has its own DNA, distinct from the mother and father, meaning that it is neither part of the mother nor the father. As the embryo grows, it develops a heartbeat, its own circulatory system, and its own organs. From conception, it is a new organism that is alive and will continue to grow and develop as long as nutrition is provided and it is not ended. I have a study here for the National Geographic, put together a television program back in 2005. In their documentary, I'm going to summarize for you quickly. They said the two cells gradually and gracefully become one. This is the moment of conception when an individual's unique set of DNA is created, a human signature that never existed before and never will be repeated. Back in 1981, April 23 and 24, a Senate Judiciary Subcommittee held hearings on the questions of when human life begins. Appearing to speak on behalf of the scientific community was a group of internationally known geneticists and biologists who had the same story to tell, namely that human life begins at conception. And as they told their story with a complete absence of opposing testimony, The official Senate report reached its conclusion. Physicians, biologists, and other scientists agree that conception marks the beginning of life of a human being, a being that is alive and is a member of the human species. There is overwhelming agreement at this point in countless medical, biological, and scientific writings. I won't go in. I was going to go and tell you about day 1, day 2 after conception. And here is your 7-week fetus. And anyone would like to hold this and see that this has eyes, limbs. I have an 8-week fetus, 10-week fetus. If anyone would like to hold these behind me, you can see these. This is human life. I do ultrasounds also. I've seen it. I have seen it. Thank you very much.
Oh, I'm sorry, they are on my phone. Let's see if there's any questions from the committee. Are there questions for this witness? All right, would you please repeat your name?
Diane Farrar. F-A-R-R-A-R.
All right, thank you very much for your testimony. All right, is there anyone that would like to speak in opposition to the bill? How are you?
Hi, how are you? Good afternoon, representatives. My name is Allison Dries. I'm the Executive Director of NARAL Pro-Choice Missouri. I have a 4-page testimony that I'll leave here for you guys today with cited material that you can go through. But I just wanted to point out a couple of things in the matter of time. Every state that has had personhood on the ballot has failed to pass such measures. In 2008, Colorado voters voted it down. In 2011, Mississippi voters voted it down, one of the strictest states in the country when it comes to abortion law. In 2012, Oklahoma voted it down. In 2014, North Dakota voted it down. In 2015, no states enacted any personhood measures
your
No
testimony,
ability to what?
no
what are you
ability to
doing?
dictate to one another, and I agree. But life, we have no ability to dictate whose life is worthy and whose isn't, is what I'm trying to say.
But that's exactly what this bill tries to do, is dictate.
It dictates that all life has
No, it
right to
doesn't.
life, liberty, and
Because sometimes the life of the woman is in conflict with the life of the fetus. You're choosing fetus. I'm choosing woman.
Okay, and we'll talk about the creation of the life. Now, was it only the woman that helped create that life? I mean, really?
Oh, now that's getting really elementary, isn't it, Bratton?
Well, does it take a sperm and an ovum to then make that embryo?
You don't know, darling. We've got to sit down and have some coffee or something.
I have 5 kids, I do though.
Oh, I gotcha. So why are you asking me that question?
Because you're citing only one side of a life and who dictates that life, and then you're also saying that we have no protection for life, and I'm saying that all life needs to be protected, and that our founding documents specifically spell it out is what I'm getting at.
So what are you doing to protect the lives of the people who don't have health care coverage in this state?
Well, I'd say this would be great for those who don't have any health because their life is ended.
I asked you a question and I didn't get an answer.
Well, I'm the one asking the question.
Well, it's going to have to be a two-way street if I'm going to sit here.
Thank you. Thank you for your testimony.
My pleasure.
So, the clock on the wall, and so we're going to have one more witness, this witness from you, and then another witness in opposition, and then let me see if there's any information. Is there anyone here for informational purposes only? Okay, so.
There was only one room time for one witness. My name is Ike Skelton. I am the Director of Missourians for the Unborn. And I have with me 200, the exact number here, 221 witness forms of individuals that could not be here today, as well as some of the other individuals that are sitting in this room and myself. 221 are in favor of this bill. 3 of them are against, and 2 of them for informational. To let you know that we are fair in what we're doing, there are 3 in here that are against our House Joint Resolution. When I got with Representative Mike Moon on this issue, life has always been precious to me for as long as I can remember, and I became active in movement, in the Patriot movement, and getting involved in our government as we're supposed to be. I believe that life is something that needed to be taken care of first. I personally don't believe that we absolutely must protect life. What we have right now in our country, in our state of Missouri, is a culture of death. If an individual wants to kill the baby in their womb, a woman can do that. And there's very little, there's hoops and loops you have to jump through. But in the end, if you want to kill that baby, you can kill that baby. Since Roe v. Wade came around, pro-life individuals have had to come to bodies like this and beg and plead and cajole and spend millions of dollars for the opportunity to save even maybe one life. Ladies and gentlemen, it is time that we change that argument around. It is time that we protect unborn babies as the language of our Constitution says and recognize them as persons so that we will have a culture of life. And if someone wants to come and take that life, let them spend the time and the energy and their resources to beg these individuals here to be able to take that life. I would ask this body to vote do pass when you get into executive session. Pass HJR 98 out of this session so it can move forward. As I believe Representative Bratton said earlier, the people of the state of Missouri will once and for all be given the opportunity to speak on this issue. Thank you.
Thank you. Other questions for this witness? Thank you for sharing the witness form. Good afternoon.
Good afternoon, Madam Chair, members of the committee. For the record, Sarah Rossi, Director of Advocacy and Policy with the ACLU of Missouri. I'll be very brief today because I think this is a simple argument, and also I'm feeling a little sick, so I'm not going to talk long. Thank you for the sympathetic noise. The reason that most states, all states I believe at this point, don't have a constitutional amendment in their state constitution regarding personhood or the right to life beginning with the stage of conception is because when these resolutions have been proposed, state by state, they go one of three ways. The first way is that it's proposed, generally passes through one house, either the Senate or the House of Representatives, and then cooler heads in the opposite house prevail because they know that passing a constitutional amendment such as this or putting a constitutional amendment such as this on the ballot is futile because in the end, it'll be overruled in the courts or struck down by the voters. That has happened time and time again in multiple legislatures. The second thing that will happen is it will pass the House, pass the Senate, the governor will sign it or not sign it. If it moves towards the ballot, there will be litigation to keep it off the ballot. And if that litigation is successful, which it has been when it has been, a few times when it's been sued over before it got put on the ballot, it won't be on the ballot for the same reason that these kind of bills and amendments are unconstitutional in conflict with the United States Constitution and Supreme Court precedent. The third thing that happens is it passes out of the legislature. The ballot language is approved by the Secretary of State. Maybe it's challenged before it actually goes on the ballot. Maybe it's not. It goes onto the ballot. The voters don't approve it, and then it dies. And we've seen that happen in multiple states as well. When it gets on the ballot and voters overwhelmingly vote to keep it out of the Constitution. The fourth thing that happens, and I think I said 3, but I meant 4. Again, sorry, sick brain. The fourth thing that happens is that it passes through the state legislature, it goes through the SOS process, it gets put on the ballot, the voters vote for it, and then it's challenged after the fact and struck down in court. So at every stage of this process, no matter how far this goes, at some point, it is either viewed by the state legislature, the voters, or the courts as unconstitutional, in direct conflict with the United States Constitution and direct conflict with Supreme Court precedent. I know I've said that before about other bills, but this is literally the root of a constitutionally protected right to access medical care in the form of abortion. It is the very beginning and start of that process, and passing personhood, while it seems good on paper for people who care very deeply about this issue, I know there are a lot of those people in the room today, in the end, it will not be successful. And it will be a waste of the state's money and resources to put it on the ballot, present it to the voters, and then eventually have to defend it in court. That's the basis of our argument. I think that's all I've got for you today. Thank you.
Questions from the committee? Representative Bratton.
To inquire. But you would, if this is an HJR, you had mentioned that it would have to go to the governor. HJRs, if they pass both bodies, just go straight to the ballot. They don't go to. Okay. Now, has there been any precedent of a personhood amendment passing and going before the Supreme Court?
In Missouri? Anywhere?
Anywhere.
In the Supreme Court of the United States and the Supreme Court of the state?
On state, any Supreme Court? Like
yes, multiple times, and they've been struck down.
Okay, within the state Supreme Court multiple times, or the U.S. Supreme Court?
The U.S. Supreme Court has ruled on personhood multiple times in the form of allowing abortion in the country. State Supreme Courts have ruled on multiple HJRs like this or HJRs like this, and they've been struck down.
But they have passed on the ballot, and
sometimes.
Okay. Now, what states have they passed on? We heard a few states that.
I know Oklahoma was sued before it even got on the ballot, and the Oklahoma Supreme Court struck it down. Georgia's tried to pass one a bunch of times, and I don't think it's ever actually gotten out of the Georgia House. Mississippi Supreme Court struck one, or Mississippi's failed to get on the ballot because it couldn't get the signatures. Who else? I can send you a list if you'd like.
Well, if you could, I'd just like to see where.
No problem.
You know, so thank you, I appreciate it.
Yeah.
Seeing none, thank you very much. Your testimony, be sure to leave us a witness form. Representative Amended, do you have any closing comments?
Informational purposes, right?
I don't see any informational purposes.
Thanks for allowing me to close real quickly. You know, when we look at the 10th Amendment, anything that's not specifically given to the federal government is restricted to the states and the people. I had a brief conversation with former Missouri Supreme Court Justice Mary Russell. I asked her because there was a bill going through the House and it had actually gone through and the court had ruled on it, and they had ruled contrary to what the intent of the legislature was. So I said, Justice Russell, tell me what should happen in cases like that, whether it's at the state level or the federal level. She said, well, honestly, the court doesn't know what the intent of the bill or the legislature is. So when that happens, the legislature needs to correct the courts by enacting new legislation. This is a case in point. So whether or not this is ruled on by the Missouri Supreme Court or by the U.S. Supreme Court, the will of the people is what needs to be heard. And that's why we need to get this to the ballot so that we can protect the true health of women and their unborn children. Thank you very much.
Thank you. I know there's many who have come wishing to testify. The time that we have allotted has expired. However, you can fill out a witness form. They're available here at the desk. And on that form, it asks if you support or oppose the legislation, and those are always very valuable to us. And whether you got to speak or not, being here, filling out that form, you're certainly free to email any testimony to us that you may feel we need to see. But those are the kind of things that make your voice heard in this process. So thank you, and that concludes the hearing on, get it right, HJR 98. Thank you, Representative.
I just wanted to say that there was a very important witness from the reproductive justice table who was here in the building and had to step out and got cut off. I just wanted people to know, particularly in light of the name of your other bill, All Lives Matter, that there was a reproductive justice response to that wasn't able to be heard today, but it's included in the witness form. Thank you.
I would like to mention that there's a lot of people, Madam Chairman, that were not able to come here today. And we would like to show how many people there were. Sorry for the mess, but these are roses for life. These are distributed by the Knights of Columbus around various parishes in Missouri. These are only from Southwest Missouri, a little bit of Southwest Missouri. Now, these represent, each one of those represents a person who does not agree with stamping out the life of an unborn child. Go ahead.
All right, thank you.
Thank you. And Madam Chairman, I should have pointed out, we had over 9,000, probably as close to 10,000 signatures. These very stations all across the state. Thank you very much.
Thank you. Thank you all very much. All right, the next bill that we're going to take up is House Bill 1953. Ladies and gentlemen, quiet
It's just right here. It's just right where I need it. It's a stack.
All right, Representative Swan, thank you for being here today, and we really appreciate your kind of standing in line here today. You may proceed with your presentation of House Bill 1953.
Thank you, Madam Chair, and certainly not an issue. Members of the committee, Kathy Swan, District 147, Cape Girardeau. I will be very quick in the presentation. I do know that we do have witnesses who wish to testify. The other reason, this is the third year that I've filed this bill, so you should be quite familiar with it, and it is the inspection required annual inspection of the clinic itself. So it is very similar, obviously, to last year's HB 190, which is entitled the Women's Healthcare Protection Act. It did pass out of this committee last session. It was on the House floor, passed the House by a vote of 119 to 35 last February, and subsequently it was sitting there installed on the Senate informal calendar at the end of last session. The bill is also quite similar to House Bill 1478, again from the 2014 session. It also passed out of the committee, which passed out of Healthcare Policy Committee in 2014. It was also on the House calendar. There are 4 provisions to this bill. One is proper handling of tissue and reporting requirements. Second is physician requirements. 3, facility licensure, and 4, annual inspections. The tissue reporting section you will find on pages 1 and 2. The difference in current statute and this bill language is current statute indicates that a sample or a representative example of tissue would be submitted. The bill language indicates that all tissue removed at the time of abortion shall be submitted to the pathologist, and the tissue report shall contain a certification that all submitted tissue has been disposed of according to state law and done properly. The annual report to the General Assembly by the department would begin on January 1st, 2017. It would contain the following information for each procedure regarding the type, the estimated gestational age of the fetus, the confirmation as to whether the department received the tissue report, and the certification of the disposal of the remains and any inconsistencies in reporting that might be found between current requirements and the tissue report. Page 2, physician privileges, is just additional specificity regarding the language, statute language, replacing the word clinical by surgical and admitting privileges. Today's world of healthcare, there's that common terminology is surgical privileges and admitting privileges. So this is an update to current practice and current language. Nothing changes. It must be the privileges at a hospital offering OBGYN care within 30 miles of the abortion facility. Page 3 regards facility licensure, just indicating that all applicants for this type of facility will meet all state and federal law and regulations for licensure. Currently in statute, we do have regulations regarding ambulatory surgery centers for licensure. The department then also may not waive these requirements as a condition of any litigation, settlement, or any other agreement. Finally, on page 4 is the annual inspection language, of which I'm sure that you're familiar with since we passed it on the House last session. There will be at least one unannounced on-site inspection that will be made annually of any ambulatory surgical center operated for the purpose of performing or inducing an abortion. The inspection shall include compliance with all requirements for the ambulatory surgical centers as required by state law, requirements with current statute regarding tissue reporting that's in 188.047, the tissue submitted to a board-certified eligible pathologist, and the tissue report be made part of the patient's permanent record. Requirements with current statutes for proper consent forms prohibiting the purchase of sale of body parts, which is in statute, and prohibited abortions, which is defined in statute. Plus language is added to statute that no donation or gift of fetal organs or tissue may be made to any person or entity for medical, scientific, experimental, therapeutic, or any other use, as well as language that would prohibit payment for final disposition if the disposition includes any donation or any economical gift. And finally, the compliance with existing state statutes prohibiting the use of public funds, public facilities, and public employees to perform or assist in a prohibited abortion or encourage a woman to have a prohibited abortion. Just for the sake of clarification, a prohibited abortion is one that's done with the intent to use fetal organs or tissue for transplant, scientific, experimental, or therapeutic use. That's found in 118.036 currently. Currently, annual on-site inspections are not required for ambulatory surgical centers. In addition, the inspection investigation reports shall be made available to the public. But regardless of the medical procedure, all patients are entitled to and should receive the best quality of care possible by qualified healthcare professionals who follow proper protocol and safety procedures, ensuring clean equipment, administering current unexpired medications, using current unexpired medical supplies, and who are compliant with state laws regarding licensing regulations and reporting. It is about healthcare and quality healthcare, and our healthcare should not be dictated by an illness, treatment, or specific procedure, and certainly not by gender. I do have the information. I'm sure that you remember from last year. I will not go into the inspections and what was found, but as a former infection control nurse, I was appalled at the violations that were found at the clinic. I do have that information for you, and I can repeat that for you if you have questions regarding specifics. And I simply respectfully ask that since this bill was passed in the House last year, that we allow it to proceed, and if it's not, it's kept out today, which I know you do not have time, that it is done very soon. So I will be glad to answer your questions.
Are there questions from the committee? Representative.
Thank you. Commissioner Clark.
You may.
Page 4 talks about making pathological findings part of the patient's permanent records. In the next sentence, it says review of the patient's records. But on page 2, it talks about the confidentiality of the patient. How do we make sure that their information will stay confidential if it's being reviewed?
Patient information is always reviewed by a Joint Commission of Hospital Accreditation and any other accrediting body, both of inpatient hospitals and any ambulatory surgical centers. They are obviously bound by law to keep all information regarding a specific patient and patient's information confidential.
Thank you, I think.
You're welcome.
You're welcome. Other questions? Steve, do you have a witness that you'd like to move forward?
I believe we do.
Thank you.
Madam Chairman, members of the committee, my name is Patty Skane. I'm the Executive Director of Missouri Rights Life and also a registered lobbyist with our organization. Representative Swan has had this bill, as she said, for 3 years. It's been expanded somewhat based on the videos that were shown last year and also the investigative hearings. And we very much appreciate her offering this bill. We also appreciate the bills that have already been heard this year, Representative Franklin's bill and Representative King's bill. We really believe that those bills should all be combined into one bill, all these bills. We know that the videos that were distributed last year or disseminated showed things that were going on in the abortion industry and some possible connection with Missouri. And that's what has brought about this legislation to a certain extent. The expansion of it, at least, is we know that abortion clinics have been unsafe for many, many years. There have been over 24 sightings of ambulances at the St. Louis Planned Parenthood over the last 4 years or so. And so it's very imperative and important that these clinics be inspected so that Missouri citizens are protected and they are in a safe environment. And so, again, the reason for the bill. The investigative hearings highlighted also that there were obvious holes in our procedures as far as, number one, the University of Missouri issued a refer and follow privilege to the abortionist in Columbia, which does not satisfy Missouri law. And the state of Missouri Department of Health issued a license to that clinic based on that, in violation, really, of Missouri statute, because it does not satisfy that law. These kinds of things we have to have oversight of. Women have to be protected. They have to have an abortionist, if they have to have an abortionist, and we wish they didn't, but that can treat them if there's an emergency. and they have to be taken to a hospital. And we have seen in St. Louis that that's happened numerous times. And so that is something that is important for the safety of women. This bill needs to track the tissue that's being harvested from these abortions and find out what's happening and prevent the selling of these baby body parts. I didn't get a chance to say it at the last hearing, but you know, we talk about all these medical terminologies and things. You know, the word fetus, it's just a Latin. It's, you know, medical field and the legislative or legal field, they do a lot of things in Latin. The word fetus is just Latin for little one. That's all. That's what it means. And you know, we argue about using these terms. If you just define it, we'd be talking about a baby. So we want to make sure that these babies are not violated. Is a violation enough that they're killed in utero? But then to harvest their parts and to sell them for profit is unconscionable and not a society, a thing that we should have going on in a decent, humane society. We do, the Senate bill that is complementary to this bill, 644, has been amended to allow that specimens will be allowed for criminal cases if they need tissue specimens, and so we would definitely encourage and support an amendment to this bill that would also allow that. You know, another important thing, again, as we said, because of the licensing, is the definition, the clarification of the definition of refer and follow privileges, and that it be specifically be privileges to perform surgical procedures. And I'll go ahead and answer any questions.
Right, committee members, our time is waning, and I want to be sure and give an opportunity for those that are in opposition of this bill to speak. So that's the next witness, and we're just going to bypass the question. I see the chairman of the next committee is out in the hallway with the gavel. They'll be in here to gavel me pretty soon. So thank you for your testimony. Be sure and your witness form. Representative Swan, I asked in opposition testimony for you to slide over to give way, and we'll accept testimony in opposition to the bill. Thank you. Thank you.
I think you probably remember who I am. Ed Weiss, fired up family physician in St. Louis. I'll be brief. I have at least three concerns that I'll focus on about this bill. The first is the requirement for surgical and admitting privileges at a hospital. So on the surface of it, that sounds like a great idea. I mean, why wouldn't you require that versus doing a procedure? Of course, you want them to be available in the hospital. If you bear that out, though, I'm not an OB-GYN. I'm a family physician. I treat hypertension and cholesterol and diabetes. My patients get heart attacks and strokes and things like that. And I don't do bypass surgery. I don't do angioplastics. I don't do any of those things. So if this makes sense to require hospital and surgical privileges for an OB-GYN doing an abortion, you should probably require every family physician in the state to have hospital privileges for doing bypass surgery and starting dialysis and all of the other things that go wrong. Of course you wouldn't do that. That would be absurd. And instead, what is common practice is that physicians doing procedures who are doing the job properly know other physicians whom they can refer to. So those referral networks are what you need, and we all have those things. That's what emergency rooms do, for example. A second problem that I have with this bill is the drive to increase the inspections of procedures that of centers that perform these procedures and increase the pathology reporting. Again, on the surface of this sounds like it would be a reasonable thing, but you already know that abortion procedures are actually among the safest and least complicated of procedures that we do in the country in medicine. And if this makes sense to require this increased reporting for the one, increased inspections for the one, we should certainly apply that to things like colonoscopy suites, endoscopy suites, and all of the other ambulatory surgery suites. If we don't do that, why are we picking one of the safest of places? And the reference was made by the previous witness that there were 24, I think she said, ambulances brought to Planned Parenthood. Well, the clinic that I directed for several years in Chicago, I'll bet we had maybe 10 ambulance visits per year, but we did 5,000 office visits per week. 5,000 visits per week. So how many, and we called an ambulance when there was somebody who we were worried about and wanted to make sure they got to the right level of care for what was wrong with them. the number of ambulance visits, absent the outcomes of that and the frequency of how much activity is going on, doesn't mean anything. And when you look at national statistics, this is actually among the least dangerous of things for women to have done. Certainly safer than going through a pregnancy in terms of mortality. Lastly, the question that really drives me crazy is that in this bill, you want to make it illegal for a woman to donate tissue for research. You want to make it illegal for a woman to donate tissue for research. First of all, my understanding is it doesn't even happen in the state of Missouri. That being aside, if you want to outlaw tissue donation for research, because that's your belief, that's what you might want to do. But then I would ask you to put together a pledge to never use in your life or in your family's life any of the emerging treatments for strokes, heart disease, diabetes, spinal cord injuries, burns, Parkinson's disease, blindness, Alzheimer's disease, name more. You know, if you're going to co-op the research for those things, I think you should take a public pledge to promise that you would not use the benefits of the research that you're impeding. Thanks.
All right, thank you very much for your testimony. Thank you. Is there anything here for informational purposes only? All right. Representative Swan, do you have any closing comments?
Thank you, Madam Chair.
Yes. We have 2.2 seconds to do that, okay? No, you just said thank you, that's it. Okay, great, I'm sorry, I was looking at my clock.